Have you ever walked into a negotiation, perhaps buying a car or a house, and found that the very first number mentioned, perhaps no matter how outrageous, seemed to subtly stick in your mind, shaping all subsequent discussions? It's a common human experience, this persistent pull of an initial suggestion. Well, this fascinating psychological phenomenon has a name: the anchoring effect. It's a powerful cognitive bias where our judgment becomes unduly influenced by an initial piece of information, or anchor, even if that information seems entirely irrelevant. Think of it like a mental weight dragging your thoughts towards that first number or idea. Pioneering researchers Daniel Kahneman and Tversky in the 1970s were among the first to truly illuminate these mental shortcuts, or heuristics, showing us how easily our brains can fall into predictable patterns that, while efficient, can sometimes lead to systematic errors. Now, imagine this powerful effect at play in a place where decisions carry the highest stakes, a courtroom, specifically in the complex and critical process of legal sentencing. Today, we're going to explore what research truly says about anchoring in this vital area, uncovering how it might silently shape the very fabric of justice, affecting both judges and juries alike. At its core, the anchoring effect is simply our human tendency to lean too heavily on that first piece of information encountered. Subsequent judgments, even if we consciously try to adjust them, often don't move far enough from this initial reference point. It's a subtle but significant pull, often operating beneath our conscious awareness. In the high-stakes environment of sentencing, these anchors can emerge from various sources. One of the most prominent sources is the prosecutorial demand. When a prosecutor recommends a specific sentence, that number often acts as a very strong anchor, causing judges' ultimate sentences to gravitate towards those initial figures. Think of it this way: if a prosecutor suggests a 10-year sentence, even if the judge initially believes 5 years is more appropriate, they might unconsciously settle closer to 7 or 8, subtly influenced by that initial 10-year anchor. But it's not just prosecutors. Sentencing guidelines, while meticulously designed to promote consistency and fairness, can paradoxically function as anchors themselves. Instead of offering a broad, unconstrained framework, they can sometimes narrow the perceived range of appropriate punishment, subtly influencing judicial discretion. Even seemingly innocuous details can serve as anchors. Studies have shown that judges can be swayed by entirely irrelevant numbers, perhaps a number mentioned in passing during a case, or even one from a journalist. And simply expressing a sentence in months instead of years, for example 24 months versus 2 years, can create a larger numerical anchor due to the higher digit count, potentially leading to longer sentences. In civil litigation, the plaintiff's requested damages can powerfully anchor the jury's eventual award, often pushing it higher. Now, you might be thinking, surely experienced judges, trained in law and critical thinking, would be immune to such a simple, irrational bias. This is where the research delivers a truly surprising and somewhat humbling finding. Research unequivocally indicates that both experienced and newly appointed judges are susceptible to the anchoring effect. Not only are they influenced to a similar extent as laypeople, but paradoxically, judges may even feel more confident in their judgments despite the presence of this bias. Mock jury studies confirm similar susceptibility among jurors. This isn't about intelligence or legal acumen, it's about the inherent, deeply wired patterns of the human brain. This subtle distortion can affect how judges form judgments, how they process information, their establishment of causal relationships, and even their legal reasoning itself. It can also lead them to expend less explanatory effort when an anchor is present, perhaps feeling that the anchor itself implicitly justifies the decision. Pioneering work by researchers like Englich, Thomas Musweiler, and Fritz Strack, and the extensive writings of federal judge Mark W. Bennett have consistently highlighted this pervasive influence on judicial decision-making. The pervasive nature of anchoring in sentencing isn't just an interesting psychological quirk. It has profound, real-world implications, sparking significant debate about justice and fairness within our legal systems. One major controversy centers on the effectiveness and fairness of sentencing guidelines. While well-intentioned to ensure proportionality and consistency, do these guidelines inadvertently create anchors that overly influence judges, potentially leading to increased incarceration rates and, perhaps unexpectedly, a shift of discretion from judges to prosecutors? This is a critical, ongoing question. Then there's the ongoing debate about judicial expertise versus bias. The persistent finding that judicial experience does not necessarily mitigate anchoring bias, and that judges often exhibit increased confidence in their judgments despite being influenced, raises profound questions. It challenges our assumptions about the perceived impartiality of the judiciary and highlights the inherent limitations of human cognition, even among highly trained experts. This leads to a growing discussion about cognitive bias versus intentional bias. It's vital to distinguish widespread, unconscious cognitive biases like anchoring from deliberate, intentional prejudices or biases. Researchers argue that cognitive biases are inherent, pervasive, and often harder to address than the actions of a few bad apples. This recognition underscores that the problem isn't necessarily malice, but a systemic vulnerability inherent in human decision-making processes. And let's not forget the impact on prosecutorial discretion. Prosecutors hold substantial power in the justice system, and their discretion in charging decisions and recommending sentences directly introduces incredibly powerful anchors. The debate increasingly questions the extent to which this broad discretion should be curtailed or guided to prevent anchoring and ensure truly equitable outcomes. Perhaps most critically, research highlights that cognitive biases, including anchoring, contribute significantly to racial disparities in sentencing. For example, studies show that Black individuals are disproportionately affected, often receiving longer sentences. This isn't about individual prejudice alone. It's about how these unconscious mental shortcuts can compound existing societal inequities, raising profound public questions about systemic injustice within the criminal legal system. Dr. Atil E. Drawer from University College London consistently reminds us of the widespread nature of cognitive bias throughout the justice system. So, if anchoring is such a pervasive and deeply ingrained human tendency, even among experts, what can be done? The good news is that recognizing the problem is the first crucial step, and addressing the anchoring effect is now a critical area of research and focus for enhancing legal fairness. The future outlook involves several key strategies. Firstly, debiasing strategies are paramount. This includes active defense counter strategies, where defense attorneys consciously challenge high prosecutorial anchors by presenting lower, well-reasoned ranges or alternative perspectives. Secondly, judicial awareness and training are crucial. Educating judges about cognitive biases and their bias blind spot, the tendency to see bias in others but not in ourselves, is vital. Programs designed to raise this awareness and provide practical tools for self-correction are essential steps. Thirdly, procedural reforms are being explored. This might involve rearranging numerical information in pre-sentence reports to reduce the inadvertent anchoring effect of guidelines, fair legal proceedings for everyone. Finally, ongoing research will continue to be essential. We need to keep investigating the subtle mechanisms of anchoring and rigorously assess the efficacy of various mitigation techniques across different legal contexts. This continued research will inform better policy and practice. The recognition that cognitive biases are not merely isolated incidents but systemic issues underscores the need for continuous vigilance and reform efforts. Our shared goal is to move towards a justice system that, while imperfectly human, strives to be as equitable, fair, and unbiased as possible for all. By understanding and actively working against silent forces like anchoring, we take a significant step towards that vital ideal.